Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk about something that I think is interesting, the difference between a statute of limitation and a statute of repose, in the context of a great case from Ohio. I'll have more in just a second. There are lots of people who think that they can escape the bar of justice if they just leave the jurisdiction. Now, that rarely happens in the United States because there are these people called skip tracers who can pretty much find anyone. And once they find them, they can be served. But every now and then, somebody manages to escape out of the country. And so that's kind of what we're going to be talking about today. Somebody who thought they could escape the bar of justice by fleeing the country. So this is a case from the great state of Ohio. It's from the Ohio Supreme Court, and it has an interesting background. Let's look at that now. This discretionary appeal asks whether the 4-year statute of repose cuts off a plaintiff's time for filing a medical malpractice claim when the defendant has fled the country before the statute of repose has expired. We hold that by its plain language, RC 2305.15a tolls the medical claim statute of repose, which is RC 2305.113, and therefore the statute of repose does not bar the filing of a claim during defendant's absence. Consequently, we affirm the judgment of the First District Court of Appeals. This is one of those unique situations where you have a doctor who is not only a bad doctor, but also a bad person, and this is what has happened. In March 2010, appellant Abubakar Atiq Durrani, and I'm probably really screwing that name up, performed spinal surgery on appellee Richard Elliott at Good Samaritan Hospital of Cincinnati. Within a week, Elliott suffered pain and infection. 6 weeks later, Elliott was unable to eat or drink and had lost 80 pounds. Elliott believes that Dr. Durrani and his clinic, Center for Advanced Spine Technologies, Inc., were responsible for performing his surgery unnecessarily, negligently, and without his informed consent. He also believes that Good Samaritan Hospital was negligent in credentialing Dr. Durrani, among other failings. In August 2013, the United States government indicted Dr. Durrani for criminal fraud related to his medical practice. See United States v. Durrani, Southern District, Ohio case as shown. Dr. Durrani fled to Pakistan in late 2013, and he has not returned. Well, that's because he knows that he would get a nice little vacation at Club Fed if he indeed did return and faced prosecution. So then Mr. Elliott decided that he would pursue Dr. Durrani. In August of 2015, Elliott filed a medical malpractice complaint against Dr. Durrani, his clinic, the Good Samaritan Hospital, in the Hamilton County Court of Common Pleas. Elliott is one of hundreds of plaintiffs who have filed similar malpractice and related claims against Dr. Durrani and his clinic. Elliott's complaint against Dr. Durrani and Dr. Durrani's clinic was served in Pakistan in accord with the Hague Convention. That is a convention which allows for the service of lawsuits both from citizens in other countries suing an American and also from Americans suing citizens who live in other countries. As a result, all defendants answered the complaint and filed motions to dismiss, citing the 4-year statute of repose as an absolute bar to the lawsuit. In July 2018, the trial court granted the motions to dismiss based on Elliott's having waited more than 4 years after the act or admission on which the claim was based to file his medical malpractice complaint. The court held that RC 2305, which tolls certain limitation periods for filing lawsuits when a defendant absconds, does not toll the 4-year statute of repose for medical claims. The court dismissed with prejudice Elliott's complaint against Dr. Durrani, his clinic, and the hospital. While the appeal was pending, the Supreme Court decided another case involving Dr. Durrani. In that case, the claim for medical negligence had been brought within the 4-year statute of repose, but it had been brought in the wrong county. And in order to avoid the problem with the wrong county, they dismissed the lawsuit and refiled it under what's called the saving statute. And the Supreme Court, in that Wilson versus Durrani, decided, hey, guess what? The saving statute does not toll the statute of repose. It only tolls the statute of limitations. So those plaintiffs were out of luck. So naturally, he took that case up to the Supreme Court of Ohio, and the Supreme Court of Ohio had a little bit different analysis. It took a look at the difference between the statute of limitations and the statute of repose. And it said basically there are a number of exceptions to the statute of limitations if you have not discovered something. For example, if a foreign object was left in your body, like a clip or a clamp or a sponge, that tolls the statute of limitations until that foreign object is discovered. But it doesn't toll the statute of repose. And here's what it says. In other words, RC 2305.113 starts the statute of repose running on the date the alleged malpractice was committed, not the date of its discovery. The date of the alleged malpractice and the date when the injury from which the alleged malpractice is or should have been discovered are fact-dependent and may not be the same. On the other hand, the statute of repose may preclude the filing of a claim before it has even accrued. So that's the Wilson case essentially held that. But then the court got into the exceptions to the statute of repose, and here's what it said. When a cause of action accrues against a person, if the person is out of state, has absconded, or conceals self, the period of limitation for the commencement of the action as provided in 2305 to 2314 does not begin to run until the person comes into the state or while the person is so absconded or concealed. After the cause of action accrues, if the person departs from the state, absconds, or conceals self, the time of the person's absence or concealment shall not be computed as any part of a period within which the action must be brought. So when it says within any period, that means both the statute of limitations period as well as the statute of repose period. So here is how the Ohio Supreme Court wrapped up this case. The legislature has presented us with an unambiguous tolling statute in RC 2305.15. We have no authority to apply only part of the statute, and our holding in Wilson does not require us to do so. Furthermore, our holding today is consistent with the purpose of the statute of repose for medical claims, which identifies when a defendant is entitled to be free from liability. The legislature has made clear in the statute that an absconding defendant is not entitled to a 4-year statute of repose that is not tolled. Therefore, we affirm the judgment of the First District Court of Appeals. So what does that mean? Well, in this case, what it means is that the case against Dr. Durrani remains, but the case against Dr. Durrani's clinic, which is a corporate entity, does not, because the corporate entity can't abscond. It is a citizen of the state. As to the Good Samaritan Hospital, it is a citizen of the state. It cannot abscond. And so the failure to bring the action against those two entities was not told, but he can pursue the doctor. And of course, the doctor has got some real problems in trying to defend this from Pakistan. He can't come to the United States for this trial or he will be arrested. And the people from the Hamilton County, the people from Ohio, can fly to Pakistan and take his deposition over there. But when they do that, they're going to be subject to the law as it is over there, and that may not be favorable to them. As a result, there are disabilities on both sides, and the real question may be, what happens if they are able to get a judgment against Dr. Durrani? How are they going to enforce it? Well, assuming that Dr. Durrani has either funds, meaning monies in the bank in the United States, or he has property, real property in the United States, the plaintiffs can seize that if they are successful at getting a judgment. So they may not be completely out of luck. And my guess is that nobody would pursue a case like this to the Ohio Supreme Court if they truly believe there was no money for it at the end of the day. So that's the difference. A statute of limitations says you have to bring this cause of action within 1 year. In Ohio, it's 1 year. In Missouri, it's 2 years. In Tennessee, I believe it's 1 year. The different states have different statutes of limitation, but they all also have different exceptions to the statute of limitation. For example, if the malpractice is committed against a 12-year-old in Missouri, the statute does not begin to run until he is 18, and it expires when he is 20. So in that case, the statute of limitation has this long tail at the end of it. And the statute of repose, however, in the statute of repose, for example, Kansas has an 8-year statute of repose. It doesn't matter when it's discovered. Much like Ohio, it says if you didn't bring it within that 8 years, sorry, you are out of luck. Now, the policy basis for statute of limitations and statutes of repose are simply this. Cases are best litigated when all the facts are fresh in everybody's mind. I can't tell you how many times I've deposed a doctor and they've said, well, I just don't remember. I remember the patient, yes, I remember doing this surgery, but I don't remember what I saw when I opened her up. These things happen, and it's because doctors do dozens of surgeries every week, and they can't keep all of that in their head. That's why they make notes. So that's why we have statute of limitations and why we have a statute of repose. It does serve an important public policy, which is to keep claims being litigated while they are fresh. If you have any questions about this, give me a comment down below. I would be happy to try and answer the question for you. Also, the channel has now been monetized, and so if you want to send me a super thanks, you can do that. I'm not suggesting anybody needs to do that. I'm just saying that is an option that's now available to you, which I thought was kind of neat. As always, do the things that we ask, like, share, subscribe. Comments help because they help us with the YouTube algorithm. And as always, if you have a chance to help somebody out today, maybe just give them a kind word, that'd be a great thing. It helps make this world a better place for all of us. Thank you and have a terrific day. I'll catch you on here next time.